get started. So if you could take a seat and get your food, that would be great. I don't know if the panelists can see the audience, but we have quite a few people here, so that's very exciting. So good afternoon. My name is Charlotte, and I'm one of the Symposium editors for Vermont Law Review. Welcome to our first session of the four-part Symposium series. We're really excited to kick off our symposium with today's discussion focusing on the Indian Child Welfare Act. We're honored to bring together some experts and scholars to discuss the important statute in federal Indian law, including its history, challenges, and ongoing efforts to protect the rights of Indigenous children and families. I'm going to give some short introductions that don't even begin to fully encapsulate all the contributions that the panelists have made in the field of federal Indian law and tribal advocacy, and then I'm going to give the floor to them to lead us in this discussion. So moderating today's session is Mia Montoya Hammersley. Professor Montoya is the director of the Environmental Justice Clinic here at Vermont Law and Graduate School, and she's also a professor of law teaching Native Americans in law. Professor Montoya brings a wealth of expertise in environmental justice, and her career in legal advocacy reflects her deep commitment to tribal rights. Additionally, Matthew Fletcher is another one of our panelists. Professor Fletcher is currently the Harry Burns Hutchins Collegiate Professor of Law in Michigan Law and a prominent scholar in federal Indian law. He also serves and has served as a tribal in-house counsel for Native Americans in the western United States and is an appellate judge for numerous tribes. A lot of his legal practice has framed his scholarly work, and his perspectives bring invaluable insight in today's discussion. And our third panelist is Lauren Van Schilfgaard, who is an assistant professor of law at UCLA. Professor Van Schilfgaard's research focuses on tribal sovereignty and federal Indian law. She's previously directed the San Manuel Band of Mission Indian Tribal Development Clinic at UCLA and has held various roles in tribal legal and policy development with extensive work in tribal government and child welfare. With those introductions in mind, I'd like to turn it over to Professor Montoya, who is going to lead today's discussion. Thank you.
Great. Hello, everyone. Thank you for those kind introductions, Charlotte. Can you all hear me? Great. I'm so pleased to be leading the discussion today with our esteemed panelists. So we're going to start by going back a little bit and learning about some of the foundational concepts of federal Indian law, because to understand the Indian Child Welfare Act, we need to have some common knowledge of how we got there, and to understand that, we have to go back to our roots in our Western legal lineage, starting with the Greeks and the Romans. I swear this is only going to take 10 to 15 minutes, and then I will turn it over to our panelists. So I'm going to go ahead and share my presentation. Can you all see that?
Yes.
Okay. Thank you. Okay. So the Greeks and the Romans are really the root of our legal and intellectual lineage in the West. So the roots of Indian law actually go back much farther than modern colonial history. I always like to start my federal Indian law class with talking about the Greeks and the Romans, because this is the root of the archetype of the savage that we see throughout modern federal Indian law and the doctrine of discovery, which we'll discuss shortly. So in Greek, the word barbarian is actually derived from the Greek word barbaros, which means foreigner. You can see throughout Greek mythology the depictions of foreign people as monsters here. You can see, if you remember from the Odyssey, the Cyclops Polyphemus. The Roman tradition of conquest started to divide the world into the civilized world and the non-civilized world. And the fall of the Roman Empire later and the ultimate rise of the Catholic Church continued this division, except now the world was being divided into the Christian and non-Christian world, rather than, which was an extension of the division of the civilized versus non-civilized world. So the doctrine of discovery is actually a body of legal corpus, or a body of laws, of opinions and theories on the rights and status of infidel people, right, such as papal bulls. By this point in European history, the Catholic Church is a major source of political power in Europe, and the savage archetype inherited from the Greeks and the Romans plays out throughout the European crusading legal tradition. Again, the world is being divided into a Christian and non-Christian binary. The non-Christian world, or the savage world, is seen as less than human. Again, if you think back to some of the Greek depictions of foreign, uncivilized people as monsters, as non-human entities, and that savage people are deserving of different rights than civilized people. So there emerges a different system of law for the conquest of civilized nations versus the conquest of uncivilized nations or non-Christian nations, because non-Christian peoples were considered to be ineligible for assimilation. Through this line of reasoning, many atrocities against non-Christian people were legally justified, and the doctrine of discovery is ultimately based in concepts of natural law and sovereignty. So native people, upon first contact, were considered to be ineligible to assimilate with the conqueror because they did not have the same civilized or Christian values. Okay, we're jumping ahead in time a little bit to the founding of the United States. The founding fathers were really concerned with the scope and nature of the territorial rights of tribes. It wasn't clear, well, to them, whether or not tribes owned the land in the same way that Europeans understood ownership of land. Could European concepts of sovereignty be applied in this context? Even as they're asking these questions, trying to delegitimize tribal rights to their lands, they themselves were being inspired by tribal governance systems. For example, the Iroquois Confederation is the source of concepts in our own democracy, such as separation of powers, specifying who has the right to declare war, reserving certain powers, such as family and domestic relationships, to the states. In short, our system of federalism. So the Marshall Court was the Supreme Court from 1801 to 1835. John Marshall was the fourth Chief Justice of the United States. So if you think about what was going on in the country at this time, it was a time of increasing powers of the judicial branch. The court is still very young at this point. The country is still pretty young. So the role of the Supreme Court is still being solidified. If you all remember this little case called Marbury versus Madison, which was decided by this court in 1803, which established the doctrine of judicial review for the first time. So we don't have time to get into the specific cases today, but the Marshall Trilogy is a group of 3 cases in which the court considered some of these questions about the nature of the territorial rights of tribal people. And these came to be known as the foundational cases of federal Indian law. They're made up of Johnson versus McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. So again, we don't have time to get into the details of the specific cases today, but the important thing to take away for purposes of our discussion on ICWA is that in these cases, specifically in Johnson versus McIntosh, the court officially adopts the doctrine of discovery into United States jurisprudence. So the main takeaways from the Marshall Trilogy, and again, these concepts are foundational in every Indian law case that follows into the modern era. So those foundational concepts are that at first, before contact with Europeans, tribes possess all of the powers of any sovereign. So if you all think back to your property classes and the concept of a bundle of sticks, sovereign nations also have a bundle of sticks, and this is kind of what they're talking about here. So at first, tribes possess all the powers of any sovereign. The doctrine of discovery limits those powers, and again, this is the court's interpretation. Conquest by a civilized nation renders tribes subject to the legislative power of that nation, in this case, the United States. This terminates the tribe's external powers, but tribes retain power over their own internal governance. Those internal powers are subject to qualification, limitations by actions such as treaties, congressional action, but tribes have full powers of internal sovereignty and governance unless those powers have been expressly limited. So my federal Indian law professor always, and I have my students say this also, but everything that hasn't been taken away remains. Tribes as sovereign nations, sovereign people, still possess every right of any other sovereign unless it has been expressly limited. So federal Indian law is generally divided into different policy eras where the federal government is taking different approaches to solving the Indian problem, right? And then I just wanted to throw up here the source of federal authority and federal congressional plenary power over Indian affairs. You know, every action has to have a bucket of power. So here we have the Indian Commerce Clause, Article 1, Section 8, Clause 3, which says that Congress shall have power to regulate commerce with foreign nations, among the several states, and with the Indian tribes, right? So you can see there are 3 sovereigns discussed in this clause. So we don't have time to move through all of the eras today, but in the removal and reservation eras, over 100,000 people were forcibly removed from their ancestral territories throughout the East and Southeast specifically, and forcibly marched west, largely to Oklahoma. And you can see here, this is a map that I found in the archives of the New Mexico Supreme Court that actually shows that the state of Oklahoma was intended to be Indian territory. This is where folks were removed to. So again, it's hard to know the specific numbers of the loss and the impact of this removal era, but after this period, Native people are confined specifically to reservations as prisoners of war. And again, before the Department of Interior was the Department of Interior, it was the Department of War. So again, you have to remember at this time, tribes are confined to reservations as prisoners of war. So following the reservation era, there's some frustration arising from the federal government because it appears that reservations are not fulfilling their intended purpose of civilizing tribes. Part of the purpose, in addition to opening up vast swaths of land to non-Indian settlers, the purpose of reservations was to have tribes engaging in agriculture, in civilized pursuits, and ending their own traditional cultural practices and ways of life. So at this point, reservations are places of extreme poverty and suffering, as you can imagine what it might be like being in essentially a war camp at that time, cut off from all of your traditional practices, food ways, life ways. Many people are not located in their ancestral territories anymore. So although reservations were discussed as permanent homelands as tribes, in reality, the understanding by the federal government was always that reservations were intended to be a temporary situation for tribes, because that land could then be reclaimed once Native people had been fully assimilated into Western society. So at this point, given the frustration, the state of the reservations, there starts to be a new federal policy towards, what do we do with all of these Native people that we have removed and confined and brutalized for decades and decades at this point. So assimilation was seen as a more humanitarian option, as opposed to like outright violence and extermination. So during this time, generally known as the Allotment and Assimilation Act, started with the passage of the Dawes General Allotment Act of 1887, which we don't have time to talk about today, but the impact of the passage of this act is the loss of 2/3 of all tribal lands, or about 41 million acres lost through allotment. Another policy happening concurrently to allotment is the boarding school system during this time. So the boarding school system was established by the Indian Service, now Department of Interior, and in operation from approximately 1880 through the present day, although boarding schools serve a different, the purpose has evolved over time. The first federal Indian boarding school was established on the Yakima Reservation in Washington in 1860. The early schools were located on reservations, but educational policy later required that schools be located far away from Indian communities to facilitate their assimilationist purpose. So some of you have maybe heard of Richard Henry Pratt. He was a Civil War veteran, and in 1875, he was assigned to guard a group of the most hostile prisoners from the Southern Cheyenne tribe, Comanche, and Kiowa tribes at Fort Marion in Florida. So he conducted a little non-consensual experiment during his time there. He selected 17 of these prisoners to test out a theory about assimilating them into white society through Indian education. So he actually sent these 17 Native prisoners to the Hampton Institute in Virginia, which was at that time a boarding school for Black children. He found that the prisoners adapted completely to European American ways, and this encouraged him to open an all-Indian boarding school of his own. This boarding school, known as Carlisle Industrial School, became a model for the boarding school system into the future. And here you can see he is the one who spoke this really famous quote of "kill the Indian, save the man," but the larger quote was actually given in a speech that he was presenting at the National Conference of Charities and Corrections. And he said, "A great general has said that the only good Indian is a dead one, and that high sanction of his destruction has been an enormous factor in promoting Indian massacres. In a sense, I agree with the sentiment, but only in this, that all the Indian there is in the race should be dead. Kill the Indian in him and save the man." So I'm sure some of you have heard this before. And again, you can see how the idea of removal and assimilation is presented as this like more humanitarian option as opposed to violence. So really briefly, some of the legacy of the boarding schools. So 19 boarding schools accounted for the deaths of over 500 Indigenous children. This number will continue to rise as more discoveries are made. Separation from family, separation from culture contributes to chronic health conditions. It leads to increased risk for PTSD, depression, unresolved grief, intergenerational trauma, and epigenetic alterations. And it leads to generational gaps in language proficiency, cultural knowledge, which was the intention of these large-scale separations. So very briefly, separations of Indigenous children extended beyond the boarding school period. It was also continued by something called the Indian Adoption Project in 1959. The purpose of this project was to reduce populations on the reservation, thus lowering federal costs and creating supply to meet adoption demand by white families. So through this program is a continuation of the trends of boarding school removal. State and private child welfare agencies, backed by courts and the federal government, engaged in systematic removal of Native children from their homes, largely propped up by vague allegations of poverty and neglect, and that are rooted in an ignorance of traditional Indigenous family structures and culture. So this led to 25 to 35% of all Native children being removed from their homes. And as recently as a generation ago, a third of Indian children were still being removed from their homes. So this leads us to the passage of ICWA, and I will actually end there with a quick note on another case that was passed very soon after ICWA was passed, called Morton v. Mankari. Again, no time to get into the details today, but the important thing to take away from this Supreme Court case is that tribes are a political classification, not a racial classification, which is pertinent to our discussion of Brackeen. So I will leave it at that and turn it over to Professor Van Schilfgaard.
Thank you, Professor Montoya Hammersley. Hi, everyone. I'm Professor Van Schilfgaard, talking to you from the West Coast in Los Angeles, traditional homelands of the Gabrielino Tongva and the Fernandino Tataviam. I'm a member of Cochiti Pueblo, a tribe located in New Mexico. I grew up in Albuquerque, and now am an assistant professor of Indian law and criminal law. It's a real pleasure to be here. Thank you so much for inviting me to be here and for centering this topic. It's been an incredibly active decades in this area, most notably the recent Supreme Court decision that my colleague Professor Fletcher will be discussing. I wanted to sort of pick up where Professor Montoya left off. I think this context was really, really useful, and just a lot of it strikes me as incredibly fascinating, but also for how relevant it is. It feels like the boarding school era was a long time ago, that it was a past iteration, something that, was unfortunate, but also has less relevance for the ways that we operate today. I think one of the takeaways for what ICWA is and where our logic of how to approach these cases is that it's actually not that long ago. More importantly, the logics continue to infiltrate the law as it is today, which is, I think, important to be aware of, because I don't think courts are bringing that type of awareness, but it also informs how we might approach any remedies. I went to a school called the Manal School, or the Manal Presbyterian School in Albuquerque. I went there because I asked my parents. I didn't like the public school I was in, and so I requested for a change. And Manal School was known within Albuquerque as being a private alternative. We weren't Presbyterian or even practicing Christians, but it was great for me. It was established in 1881. It had boarding option for the entire time I went there. It had paused, but it's now since restarted that boarding. I wasn't, it often was described as a Hispanic school available for students who lived in rural parts of the state who wanted access to an education. There was also a high concentration of Native students that went there, myself included, but also students that would board there whose families were at the various pueblos or other reservations in the state. It wasn't until after I graduated that I made the connection, because this was not explicit while I was there, that Manal was established by the Presbyterians after the Bureau of Indian Education had taken over their original charter, which was the Albuquerque Indian School, operated 1 whole mile down the road. The Presbyterians had felt really strongly about their mission at the Albuquerque Indian School. And even though the federal government had taken it over and effectively dismissed their participation, they wanted to continue. So in 1893, they opened what is now the Manal School campus with the same, I think, values and charge to provide access to education. I think it's certainly influential in my life, just for the extent to which I was like in the halls, not even really fully appreciating what was going on, because I think that the fact that that wasn't explicitly discussed is perhaps revealing about our feelings of what that relationship and dynamic is. But I also think it speaks to like those underlying values. I believe when they say they really had the best interests of the pupils at heart. I believe when they say they want to continue those values, not just throughout the 20th century, but into the 21st century, informing my own education, that this is coming from an altruistic place of service and giving, and about what makes for a beneficial education. Professor Montoya talked about, some of the values informing Colonel Pratt, but I think importantly, many others around him, including a society that would meet at what is known as the Mohawk Conference in upstate New York, I think relatively close to where you all are now, of philanthropists and community leaders and business leaders, identifying the poverty on Indian reservations as vile and in need of intervention. But that intervention was guided by some principles that Indigenous people suffered not because they were conquered or because their sovereignty was imperiled and invalidated under US law, even with treaties that purport to uphold and protect that sovereignty, but because Indigenous people had yet to assimilate into the American polity, that they were being denied participation in the American dream. So the goal was, how do we facilitate their assimilation? The guiding principles for the Carlisle Indian School, as well as for the Manal School, was that pupils should be educated in forms of individuality, citizenship, Christianity, and private property. That these are core American values, and to the extent that we can help instill that into the Native population, assimilation will take care of itself. There were a number of abhorrent aspects of the boarding school era. They were intentionally dislocated from Indigenous communities, a sense that this assimilation project only has a prospect of success to the extent we can separate the child from their family. That's now known as cultural genocide. Intentionally separating children from their families is not good. But they were also woefully underfunded. Disease was rampant. There were simply minimal resources. In 1928, what is known as the Merriam Report, a federal report that's like, how are the Indian schools doing? There wasn't a rejection of the underlying values. The idea that Indigenous children should be instructed and instilled with individuality, reverence for private property, for citizenship. No, the critique was that the boarding school project was never fully resourced. There wasn't enough money and bodies that was thrown at this, and so it didn't have a chance for success. That was the rejection of the boarding school era. I think that's all relevant in part because I think that this is a history that we're only now beginning to contend with, confronted primarily because Canada is having to confront their own embrace of the boarding school era with the First Nations peoples in Canada. And this is all, right, even at Manal School, this is all very only just now coming to the surface. But I think the rejection of the boarding school era is not just about the extensive amount of trauma and abuse that took place there. The fact that they were completely under-resourced, that you had children who weighed less at the end of the school year than they did at the beginning. Many children who died and were not even provided their own grave, but were buried in mass graves. But the underlying values, right? I don't think we have necessarily contend with whether or not that was a good or bad idea. The idea that being Native is inherently anti or pro-American. This is relevant because of what happened after the boarding school era. The boarding schools were eventually shuttered, not all at once. They were effectively defunded. Many continue to operate, including things like the Menaul School, where the Presbyterians took over. The Albuquerque Indian School operated into the 1960s. Many are still in operation today. For example, the Sherman Indian School in Riverside, California, just down the road from myself. But the notion of should Native people continue to be assimilated into the American project, this continues via a form of child welfare. I think it's important to go back then and think about what is the broad child welfare project within the United States. There's a lot of really interesting writings on this, and I think if you haven't taken family law, like, you absolutely should. This is a core component that I can't believe isn't required. But if we were taking a cynical view, and at least I might pluck some of this cynicism for purposes of where ICWA is postured, the idea of the child in relation to adults is informed from those same Greek and Roman roots, but really taking prominence in the Victorian era. The child is generally perceived to be an asset of the family, specifically the patriarch. The patriarch has property-like rights over the child, and through much of the 19th and much of the 20th century, over the wife. This is important for decision making. Certainly remnants of legal and physical custody are descendants of this idea, but it also means that the child doesn't necessarily have rights in and of themselves. They are more like a property component. So when a couple divorces, we determine custody much like we do other assets of the family and divvy it up accordingly. This informs how we then approach child welfare. We hesitate to intrude upon the nuclear family, which is what the law recognizes as a cognizable legal entity, because that would be an invasion of a property right. And per the Constitution, and certainly the values informing the Constitution, we have to hesitate before the government is going to intervene in a property right. Decisions within the family are private. That means that the law was relatively slow to even recognize as a legal concern issues like child abuse or neglect, that those were private concerns that should be addressed within the family. Later, we get this advancement of recognizing as legally cognizant abuse, which is a significant advancement, and has to be noted that a child does in fact have rights beyond the decision-making of the patriarch, and this is massive. But that property type framework informs what child welfare is, right? There's a couple of limitations that I think immediately present themselves. One is certainly the rights of the child. The second is that we only recognize the nuclear family, and so to the extent that there is any parenting or connections or relations with people outside of the nuclear family are simply legally non-existent. And a number of others that aren't worth going into. Okay, so we have these competing claims of the nuclear family and the need to assimilate children. Couple that with stigma around adoption, there grows seemingly a marketplace. There is a movement for child welfare workers to now go into families and it's register abuse, I see abuse. And I might have culturally tinted lenses when I'm looking on the reservation, and I see things like dirt floors and multi-generational homes and different language being spoken and different foods being consumed. I'm registering things as potentially neglectful. Certainly not the most robust or ideal environment for this child to access higher education or get vocational training or otherwise pursue a path towards the American dream that they might otherwise have in a non-native home. The result is we get wildly disproportionate rates of removal of Indian children from their families, not for the purpose of sending them to a boarding school, but to put them in the child welfare system specifically for adoption. This peaks in the 1950s, where we get an explicit Indian adoption project. That is where the US government is advertising and encouraging that there are Native children in need of a warm, safe code for white Christian home. Out of the goodness of your heart, these same altruistic impulses that we saw coming out of the Mohawk Conference in the late 19th century, please help save these Indigenous children, and in doing so, promote their assimilation into the American dream, which is the best that we all can hope for. You're doing a service for this specific child and for the country writ large. All of this pours out in congressional hearings, motivated by Native families who have endured decades of effectively abuse of the child welfare system, coming onto the reservation, seemingly scooping up Native children with little to no due process or substantive findings of actual abuse or neglect, with a disproportionality that is frankly shocking. You have places like Minnesota where, despite natives being maybe 10% of the population, represent over 2/3 of children in the child welfare system. At a certain point, it feels like, if not is actually, every single Native child is being removed from the home. Tribes are raising alarms that this is an emergency. Spurned via the efforts of the Association of American Indian Affairs, who conducts a comprehensive study to try and give a concrete context to Congress, we find a receptive audience. And so Congress, I think, in what was then, and certainly even now looking back, implements what can only be characterized as one of the first and most provocative human rights legislations that the world has ever seen. They they led what would only later be reflected in 2007 as a law preventing cultural genocide. What's really neat about ICWA, though, is that it doesn't use those terms. It is also not backwards looking. It is not about making reparations. It does not mention the terms boarding school. It does not seek to undo any of those harms. Instead, ICWA puts an interruption in what was this otherwise, private nuclear family framework of child welfare, and institutes some structural changes going forward. ICWA is actually not that big of a statute, but it does have a couple of different pieces. There's two pieces that I think are really important. One is it attempts to put in a couple of different places along the child welfare process that need to take place in a state court proceeding if it involves a Native child. One of the big ones is that effectively, before we go about terminating parental rights, which is a concept that effectively recognizes the nuclear family, a child can have up to 2 parents. And so if we're going to have a new adoptive parent, then we have to delete one of the existing 2 parents. You can only ever have 2. That means if a child is going to go into a new permanent placement, we have to delete these ones. It's pretty harsh. There's some critiques about whether or not that's the way that it has to be done, but that's what the system currently is. ICWA says before we're going to go about a termination of parental rights proceeding, the state or private actors that are providing services need to provide active efforts to attempt to ameliorate whatever concerns exist with the existing either biological or guardians for this Indian child. Effectively, before we rush to hit the delete button, let's at least attempt to see if this family can be preserved. In the event that that is unsuccessful and a separate permanent placement is required, then ICWA says we're going to attempt to minimize the loss, the bleeding that is taking place, in which we effectively have the extraction of all the children from this group and placed over into that group. And we're going to do that by inserting some placement preferences, often described as kinship placements. Before a child is placed with an adoptive or foster placement of strangers, most of whom for Native families tend to be located outside of the community, are there any family members that can and are willing to take this child? If there's not any family members, then we'll go down the list. Is there anyone in this tribal community that is can and willing able to take this child? If there's not anyone in this tribal community, is there anyone in any tribal community, that is anyone that is Native American, that can take this child? And then and only then can we look outside of the Native community for a placement preference, all with the goal of just trying to minimize the extraction of from the children from this group to that group. So those are like child welfare policies writ large. Many have described this ICWA as the quote gold standard, that this is these are the types of policies that are absolutely fantastic for Native children, but perhaps can and should be applied to all children, that all children should, parents should have an opportunity to have access to active efforts, and that all children should be placed with their family members. But I'll leave that debate for another day. I want to note that the other core set of principles that ICWA establishes is it recognizes the tribe. This is it's hard to overstate what a big deal this is. Professor Montoya noted, this arc of federal Indian law, starting, at the pre-United States European contact. There was a recognition, albeit hesitantly, of tribes as sovereigns reflected in treaty making, and there's been a general tepid tolerance of that recognition ever since. But the U.S. Constitution and very little of federal legislation or executive acts recognize tribes as a component that they engage with as sovereigns. And so that means when it comes to a tribe issuing a tribal court order for, say, divorce, we don't really have a formal set of mechanisms for whether or not a state court is supposed to honor that. We don't have representation of tribes that are in Congress. There's not a set of offices for tribes located in DC. Tribes have a few tribes have set up their own, but my point is that there's very few formal mechanisms of engagement. It means that when we describe what tribal sovereignty is, we often get head scratching, I don't even know what that means. ICWA is one of the very few exceptions. ICWA, first of all, says, hey, tribes are a thing. Second, we're going to recognize not just that tribes exist, but that tribes have certain authority as sovereigns when it pertains to the child welfare proceeding of an Indian child. One that includes if the family is, quote, domiciled on a Native reservation, then the tribe has exclusive jurisdiction, as in the only one. States lack jurisdiction over that child welfare proceeding. But if they are not domiciled and the state has intervened with the child welfare proceeding off reservation, then the tribe has the standing to participate as its own entity in this case. It's super massive. I find it to be quite thrilling as just an advocate for developing these type of mechanisms of how tribes can participate. But substantively, it also has incredible foresight as a human rights legislation about recognizing that we are not all just isolated individuals, but that tribes are in fact entities because they are comprised of individual members, and that those members form a collective, and that the collective has rights in and of itself, it has been incredibly powerful. There has been a lot of litigation ever since Congress was passed in 1978. The Indian Child Welfare Act faces just like untold amounts of litigation in every state in the country. It's gone up to the Supreme Court a number of times, including primarily about whether or not ICWA is supposed to apply. Child is in fact actually Indian, and if they are, whether other provisions are supposed to apply. We can go into them later if we want, but I think at this point I'll turn it over to Professor Fletcher to talk about the most recent iteration of ICWA in the Supreme Court.
Thank you very much, Lauren. So I'm going to talk about a U.S. Supreme Court case from last year, which seems a lot longer than, and maybe it's 2 years ago, I don't know. Time has no meaning anymore. Called Holland versus Brackeen. And this is a constitutional challenge to the Indian Child Welfare Act. And it failed, luckily for Indian country, 7-2. Although the court, as I will explain, left some questions open. So the challenge arose out of a series of foster to adopt kind of placements. And what those are is where an Indian child is taken from the home of an Indian custodian and placed with non-Indian foster parents. Those foster parents have agreed to foster children because they're interested in adopting children. The private adoption market is almost impossible to navigate. It's incredibly expensive. And frankly, there's not enough children for the demand. So a lot of people are enter the foster care market, so to speak, on the advice of private adoption agencies for the opportunity it presents to eventually adopt foster children. So normally in the child welfare system of every state, a foster parent is an employee of the state with a legal obligation to reunify the family, to be there for the child during the period of time that the state and parents that have lost their kids are attempting to rehabilitate those parents. And so this puts a huge conflict of interest that's very structural baked into state law, baked into the Indian Child Welfare Act as well, which is many foster to adopt parents have a vested interest in not assisting the family and not giving up their children that are fostered for purposes of reunification. And so in the case of, we'll call it the Brackeen case, that is the name of one of the foster families that is the lead foster families. There were 3 children at issue, 3 families at issue in that case, 3 non-Indian foster families in opposition to tribal members who were biological relatives of foster children and the tribes that backed them. 2 of the 3 ended in favor of the non-Indian foster families. At some point, there would be a termination of parental rights hearing, and then after that, an adoption hearing to confirm the adoption of these Indian children by the non-Indian foster families. And these things are kind of like trials. You know, the Indian parents have a right to an attorney. The burden of proof is beyond a reasonable doubt to terminate parental rights. So it's a big deal. That said, Indian people usually don't win those cases. The states all apply, and tribes do too, but states all apply something called the best interest of the child determination or standard that strongly supports the family that has the most wealth and resources. And so Indian people, in relation to non-Indian people, tend to be on the wrong end of those kind of analyses. And so that's what you had in Brackeen with 3 families. 2 of them were non-Indians who had actually prevailed in cases in their foster placement had turned into an adoption, whereas 1 non-Indian family had actually lost the case to an Anishinaabe grandma in Minnesota. Nonetheless, the state of Texas, joined at the time by Louisiana, partially Ohio, and later on Oklahoma, decided to challenge the constitutionality of the Indian Child Welfare Act for a variety of reasons. The Brackeens and the other 2 families that were at issue joined that case, so that's why we have a case called Brackeen. It could also be called Texas versus Holland or something like that. The the challenge was a broad-based challenge from all of these different parties. The first one was a question of whether Congress even had the power to pass a child welfare statute at all, either under the Indian Affairs powers of the Constitution or any part of the Constitution. And the second one was an equal protection challenge, arguing that ICWA had created racial classifications that normally under the Constitution would have to be subject to a strict scrutiny analysis. The third and major challenge was something involving the non-delegation doctrine, which is a, iffy sniffy kind of constitutional doctrine that once existed for the Supreme Court to conveniently strike down acts of Congress it didn't buy politically, which sounds a lot like our current era. But the non-delegation type challenge itself was related to the fact that states actually have to follow some aspects of tribal law, such as the placement preferences and some other things that states normally have to do. They just follow their own laws. And the final challenge was a challenge to the administrative regulations that the Department of the Interior promulgated in 2016 or 17 to try to create to fill up some of the ambiguities in the statute after about 40 years of practice. And so those were the four major challenges under Brackeen. The first one was the big one, because if Congress doesn't have the power to pass the Indian Child Welfare Act, one would hazard a guess that Congress doesn't have a lot of power to do much of anything in Indian affairs. Luckily, the Supreme Court rejected this roundly. There has never been an act of Congress in Indian affairs that has ever been struck down by the Supreme Court. I don't anticipate that ever happening. The times where the Supreme Court has struck down or refused to enforce an Indian affairs statute is not because Congress doesn't have the power to pass such a law, but because there might be another provision of the Constitution that limits Congress's power. Most notably, for example, the takings clause of the Fifth Amendment. You can't take tribal property that's a vested property interest without just compensation. So a couple of statutes have been struck for that purpose, but that's basically about it. And so the court's analysis is actually very simple, which was we can't find a single case of hundreds, literally hundreds over the course of centuries, where the court has struck down a statute for lacking congressional Indian affairs power. And there was no other kind of power that existed in the Constitution, a restriction on that power that they could locate. And given that enormous breadth of history and precedent, they weren't really willing to go down that road in this case. And that was a big sigh of relief for Indian country, to be sure. And I could talk a little bit more about those details. That fight continues on in the pages of law review articles and in concurring and dissenting opinions, most notably between Justice Gorsuch in favor of congressional power and Justice Thomas and Justice Alito in opposition to congressional power. But at this point, it really is academic. Congress has, at one point, we used to call it plenary power, but it's pretty much plenary power under the Constitution in Indian affairs. The second big one was the equal protection component, and this is the one that the Supreme Court punted on. So remember, there are two sets of plaintiffs challenging the constitutionality of the statute. The first were states. So an equal protection challenge cannot be brought by a state. The state is not a person. So Congress isn't discriminating against the state of Texas on the basis of race because Texas isn't a race. It doesn't have a race. So the court kicked that part out. On the question of whether the foster families had an equal protection challenge, the court said, well, we can conceive of a possibility where that would be the case. So yes, maybe Congress has the power under Indian affairs to pass a statute like this, but there may be limitations on the back end, such as the Fifth Amendment's due process clause, which contains within it, according to the Supreme Court, an implied equal protection component. So if Congress passes a law that creates a racial classification, generally speaking, those would be subject to a strict scrutiny analysis. We saw a case like that, not about Congress, but about states. The Harvard affirmative action case from last term is an example of what happens to a strict scrutiny type situation. They usually get struck down. So in this case, you have individuals who are making a claim, and typically individuals do have standing. Unfortunately for those individuals in the Brackeen case, they didn't make a claim that was to which they actually had standing, to which they had they never really even suffered an injury. In fact, for the most part, the cases are moot. Adoptions were all completed, but more importantly, the only parts of the statute that can be subject really to an equal protection challenge are the third placement preferences that Lauren mentioned earlier. In the event that, you know, a biological relative who's a tribal member or another member of the same tribe, the third preference is Indians from anywhere. And what an Indian family is under that very specific provision is really isn't defined by Congress in ICWA. So it could be, you know, it could be a race-based classification. We don't know. The problem for the plaintiffs in this case is none of them were subject to that preference on the negative end, so they couldn't make the claim in this instance. The non-delegation thing was kind of a nothing burger. The Supreme Court did reject that because really it's not a real doctrine. And to be frank, the Supreme Court has focused mostly on, in the question of non-delegation, on something called the major questions doctrine, which is if Congress gives jurisdiction and authority on a vague question, a major question, and without really any restrictions on that, then the Supreme Court will strike that down, and ICWA is not that at all. And nobody made that argument in this case. Also, you should note that, you know, the non-delegation doctrine is not a problem when Congress does authorize other sovereigns to exercise federal power. It does it all the time. Usually in environmental protection, Michigan, for example, the state of Michigan has, where I'm from, has jurisdiction to enforce a Clean Water Act within the Great Lakes, and you know, that's federal power that's delegated by Congress to the state, and Congress can also delegate power to tribes under the Clean Water Act and other federal statutes. So this was really not that interesting. There was also something called, and I apologize for kind of skipping around, but I forgot to mention the 10th Amendment challenge under what is called anti-commandeering, which is another made-up constitutional doctrine that didn't exist until right before I started law school, like in the 90s. And the anti-commandeering provision, or I guess you could say doctrine of constitutional law, is that Congress cannot commandeer the legislative prerogatives of states and force them to do things that Congress wants them to do. But Congress can, on the other hand, say federal law is federal law, and state courts in particular have to enforce it. And that's what ICWA is. ICWA does make states do a lot of things. If states want to take Indian children away and put them up for foster care or adoption, those are all optional things that states don't have to do. Though generally speaking, we have critiques, but they are things that states really should be doing in specific circumstances. Maybe not as much as they do, but like I said, we have critiques. But but ICWA itself, to the extent it commandeers anybody, it commandeers the state courts. And state courts can be commandeered because they have an obligation to fulfill and enforce federal law, which is what ICWA is. So, for example, ICWA says if you want to terminate parental rights, you have to comply with the active efforts requirement. You've got to comply with the burden of proof, which is beyond a reasonable doubt. And those are all, I guess, commandeering of state courts, but they are not commandeering of state legislatures or policymaking branches of government. So that case that attack got kicked out as well, as did, and I won't go into it, the administrative law challenge to the 2016-2017 regulations. So that's Brackeen, and sort of where we are right now is ICWA is roundly constitutional. I'm pretty sure the only reason this case ever got anywhere near the Supreme Court was because there are judges in Texas, and that will basically strike any kind of federal statute or action down at the request of the Texas Attorney General or any other conservative challengers. And so they did that in this case, roundly, really without much analysis, focusing extensively on concurring and dissenting opinions from Justice Thomas. And, you know, the law students in the room know this, but everybody should know that a dissent is not the law by definition. It's the loser's point of view. And that's Clarence Thomas, the loser's point of view. Nonetheless, and then the Fifth Circuit split, weirdly enough, in the 16-judge panel, 8-8, where they couldn't actually reach agreement on much of anything relating to ICWA on this question, which more or less forced the federal government to take us to the Supreme Court to defend ICWA. And it was constitutional brinksmanship writ large, where every single precedent ever imagined of the Supreme Court, every act of Congress was sort of on full display. And it's telling that oral argument lasted for 3¼ hours. I was there. It was pure hell. I'm going to tell you that right now. But we'll leave it at that. I think where we are is in a really good place. There will always be equal protection challenges out there. And if you want to ask questions about that with more detail, I'm happy to try to respond to them. But my strong suspicion and my position is, as a scholar and as an attorney, that the equal protection challenges are more or less the same as a challenge to the power of Congress in the first instance, at least in Indian affairs. And the court has not taken those challenges. They've taken them seriously, but they have not accepted those challenges. And I really don't believe they could without changing Indian law dramatically in one way or the other. So we're here where we are. And so I'll stop right there. Thank you so much.
Thank you so much, Professor Fletcher and Professor Von Schilfgaard. This is a great discussion. I feel like we've covered a lot of ground already, so I'm feeling good about this time for questions. So Charlotte, I think I want to start with just a couple of questions to get us started, and then we can open it up to audience questions. Professor Fletcher, you really answered a lot of the questions that I think had already come up from some of the students about the equal protection challenges, but I would love to talk a little bit more about the larger implications to tribal sovereignty presented by Brackeen and a potential future challenge to ICWA. So, it's come out since Brackeen was argued that the plaintiffs in that case were represented by the firm Gibson Dunn, which is the same law firm that represented Energy Transfer Partners and OnBridge, and that this has largely been a response to the uprising at Standing Rock, right, and indigenous resistance to the oil and gas industry. So I would love to hear both of your thoughts about how ICWA is connected to these broader attacks to tribal sovereignty.
Well, you're asking me to engage in some speculation as to why, these big groups are involved, but I'm happy to do that. So a challenge to the power of Congress to pass an Indian Affairs statute, which is really an existential threat to all of federal Indian law, could be seen as a challenge to the power of tribes and then the federal government to possess reservation land and trust lands that are not subject to state and local jurisdictions. And those kinds of lands also place tribes in the position of what even the Chief Justice of the Supreme Court has said is plenary power over the people on those territories. So if you could get a statute and get it struck down and saying, well, Congress doesn't have the power to pass the statute in one area of Indian affairs, then you can use the reasoning, whatever the court says, to go after other statutes. And it's apparent that there are vast and powerful elite private interests, economic interests that would like Indian tribes in a lot of places in the US to completely disappear. These are typically energy extraction type organizations. So we're talking oil and gas, mineral extraction, we're talking pipeline companies, we're also talking about agricultural institutions, grazing companies and farms and ranches, and we're definitely talking about water rights in the West. So if you can make a federal statute go away in terms of not being authorized by an act of Congress, because I don't know, Justice Thomas actually has it teed up and nobody's ever voted with him, but he just says, look, the only power that Congress possesses in Indian affairs is, quote, Indian commerce. So if it's not commerce, it's unconstitutional. And his definition of commerce is archaic to say the least, but basically it means no Indian Country Criminal Act, criminal jurisdiction statutes, no statutes related to child welfare, of course, no statutes related to the protection and tax immunities, probably, maybe not tax immunities, related to land possession or land acquisition. That sounds like commerce, but not according to Justice Thomas. Commerce is about stuff crossing, actual tangible items that could be passed hand to hand, and very little else. Manufacturing, there really isn't much to commerce, and so under his view, so that's if you were a law firm that has oil and gas activities, clients with oil and gas activities in and around Indian country, those clients are being forced to comply with Tribal Employment Rights Office mandates. They're required to comply with EPA and Indian and tribal environmental protections, Safe Water Drink Act, Clean Water Act, Clean Air Act, all sorts of statutes related to, oil and gas extraction, mineral extraction. Then you would like very much for Congress to have limited power and get some of those statutes out of the way. It's really an anti-regulatory thing. It's kind of a weird way to go about it by going after the Indian Child Welfare Act. I strongly suspect that the reason ICWA was targeted by the people it was targeted and the group that it was targeted by was because in 2013, Justice Alito wrote an opinion in which he said, basically strongly suggested ICWA is unconstitutional in his point of view, and there needs to be some sort of challenge to it. And I think it was an opportunity for well-funded right-wing organizations to try to get a civil rights statute kicked out and just keep making America crappier. And I'm so glad that they lost this case.
I totally agree. And yeah, I think Brackeen was a really interesting confluence of, I think you saw like these clear large corporate interests that were funding seemingly a smaller child welfare interest, but there was also a group that was clearly about like the extent to which Indian law writ large, but specifically the Indian Child Welfare Act, stands for something akin to like racial reparations. And so to get this out, and yeah, that the 2013 case, the adoptive couple versus baby girl, authored by Justice Alito, he starts by noting that the child at issue in that case, while being an enrolled member of the Cherokee Nation, is only, quote, 1.2% Cherokee, that is 3/256 Cherokee. And at 27 months, she was taken from the only parents she had ever known and handed over to her biological father. Clearly like vitriolic rhetoric attacking the idea that Indians are a racial category, race is an antiquated notion, we should be colorblind in this, and that means that all of Indian law needs to give way to a colorblind framework.
Thank you. Thanks, Professor Fletcher, for engaging in some speculation with me.
I did it for a couple of years with Rebecca Nagel on this land. She loves that stuff. But she actually has reporting. She actually found stuff, emails and secret meetings with, attorneys general and governors, and it was fascinating and terrifying at the same time.
Mm-hmm.
Yeah,
highly recommend the This Land podcast for those who haven't heard of it before, but it does a deep dive into the case that can give you a lot of really great background, and specifically on this last question that we just discussed as well. So before we open it up to student questions, I wanted to ask, I feel like there are so many, and you all have addressed many of them already in your talks, but I feel like there are so many persistent misunderstandings about what ICWA is and about tribes and tribal sovereignty generally, but you're like, yes, where do we even start? I would love to hear from you what you think is maybe one of the most persistent misunderstandings that you've had to address in your teaching or scholarship or work elsewhere.
Go ahead, Lauren.
Yeah, I don't even know where to begin. I think there's a perception that ICWA is anti-child or that the best interests of the child are being sacrificed because they're Native American. And so I think like the famous posturing is that it's ICWA versus the child, or it's ICWA versus the family. And I think that that's a gross mischaracterization, because ICWA is really a procedural act, and I think that it is injecting like certain just processes, right? Just like any procedural, I'm thinking about like the National Environmental Protection Act, right? Similarly, it doesn't say the environment wins. It says that there's a process that you have to go through, and in fact, like a really like tepid process. And so I think it's important that, you know, there's first of all, massive resistance to even contemplating the idea that a tribal court could be hearing a case and that a tribal court will give an opinion. There's a massive sense that tribal courts are inherently biased and will only rule in favor of the tribe, but there are just countless instances in which the tribal court has a case and determines that it is in fact pursuant to their laws, the best interest of the child to remain with the non-native foster family or with the non-native adopted family. Because the tribal courts, or any courts, they're looking at people and contexts and situations that are frequently very complicated. And so I think the animus that is geared towards ICWA, I think is ignorant about what ICWA actually is, but I also think it's driven by a sense that tribal courts are inherently untrustworthy, that's rooted in just very antiquated racism and bias.
I'd agree. That last point, I just want to make one point. I mean, a judge in the Ninth Circuit just this week wrote an opinion, a dissent, where he said that, you know, tribal courts shouldn't have jurisdiction over non-members because it violates, quote, constitutional principles, and, quote, virtually every judge is a tribal member. And this is a misnomer. I mean, I've sat on 100 tribal appellate panels in my day, and probably less than 20% of the judges, sometimes it's my tribe, so I count myself, are actually tribal members of that tribe. They're usually members of other tribes or non-Indians. And that's just these perceptions are really shocking. But the one thing
but even if they were tribal members, it's just a complete like insertion of bias that they are incapable of providing a fair determination pursuant to tribal law. It's wild.
I've been on panels out your way, Lauren, where the other two judges, tribal court judges, are non-Indians who are former federal judges, and we're all still being attacked as being too pro-Indian. So they didn't want people who look like us and think like us to be on panels and be judges, as a general matter. But the thing about Indian child welfare, and just child welfare generally, that I found having to fight against, and I was going to say the best interest standard, but the best interest standard, which absolutely does apply, it's a state law standard. I mentioned this before. It almost guarantees that the poorer family is going to lose. If you in a contested adoption type scenario, it is almost impossible for Indian people to actually prevail. And in the one case with Brackeen, where the Indian grandma actually did prevail, it's because the state switched sides when it found out the Indian Child Welfare Act applied years down the road. They just had been negligent for all that time, switched sides, and the tribe intervened, and the grandma had adequate legal representation at the best interest hearing. But that almost never happens. It's extremely rare. Child welfare as a general matter is it's a Band-Aid over a much larger societal problem, and that problem is poverty. And people that are subjected to the child welfare systems around the country are almost always poor. These cases are not child abuse cases. They are almost always dirty homes cases. There may be mental health issues, there may be substance abuse issues, but nobody's committed a crime. And so that, it's not that society wants to support people like that in terms of allowing child negligence to continue. It's that society is not willing to help people actually avoid that situation. There's no prevention of these societal ills. And with Indian people, it is exaggerated beyond that. So racism definitely plays a role, but classism, poverty, absolutely also plays a role, a critically important role. And so that to me is like the biggest thing to push back, is that child welfare, even tribal child welfare, state child welfare, whatever it is such a poor solution to these problems. And the last thing I wanted to point out, because I think there are so many misnomers. I was at that oral argument, and throughout the argument at points, the justices would say, well, how is this Indian commerce? And they would almost immediately correct themselves, because every adoption costs somebody is commerce. And we can't say that as a matter of law or policy. But when an adoption agency and its attorneys get paid $40,000 or $50,000 on average for every adoption, I don't know how else to call it but commerce. It really is baby selling. It absolutely is. And we can't say that in polite society. But there are these perverse incentives built into the child welfare system, most notably into foster care. Congress pays for foster care. The United States pays for foster care. And when that money runs out, which is typically between 12 and 15 months, that's when the state moves to terminate parental rights. They're not doing it because they think, well, this parent cannot be rehabilitated, there's no chance for them. They do it because they don't want to pay for child welfare. They want to pay for foster care. And that's a policy choice. And it's an absolute tragedy that happens all the time. It takes people time to come together, to rehabilitate themselves, to get their lives back together, to get a car, to get a job. And the state child welfare system, and frankly, most tribal child welfare systems, do not respect that in a way that would be helpful to everybody. And there are these perverse incentives. People get paid to foster kids, and you hear horror stories about that, and it's unfortunate. So.
Yeah, it made me think of a couple things. One, that tribes are their own governments, and they're operating their own tribal child welfare systems. Importantly, ICWA does not apply to those. Tribal law is at play. There is a whole perverse area. The federal government is paying for foster care. It's massive amounts of dollars, but the implementation of those programs did not have tribes in mind, so it's very difficult for tribes to access that money. Nevertheless, because of those incentives, tribal child welfare systems tend to look very, very much like state child welfare systems, down to the same actors implementing the same systems. But I also think that's why ICWA, and specifically the provision of active efforts, is really so revolutionary. And it's weird that it ends up predating what a lot of modern best interests of the child standards are, in that it says no, we actually do need to look at this family and identify what is preventing what we see as the minimum standards for the child to remain in the home. Is it the lack of a car? Is it the lack of a job? Is it substance abuse? And to what extent do we have to go out of our way, make positive steps towards helping with that, which is very different. And so much of the litigation is about states attempting to wiggle out of having to provide active efforts, which is, to me, crazy.
Yeah, thank you both. I'm seeing a question in the chat. I don't know if our online attendees are able to be given, are able to ask questions, but I can go ahead and just read this question out loud. I think it really pertains to what you all were just discussing. So this is from John. John is Native American and adopted with the privilege of an open adoption that allowed me to remain connected with my Indian birth mother and her family. Being raised by an adoption attorney, I'm well versed in the nuances and minutiae of adoption practices and standards, and have great appreciation for the protection of tribes and their continuity. I absolutely support the direction the court is moving with ICWA to frame tribal sovereignty as actual sovereignty, which typically comes without conditions and oversight. I have two thoughts that I'm interested in the panel's responses on. First, in this discussion, I'm concerned about the lack of context or the weight given to the practical application of posing child welfare as exclusively a tribal sovereignty issue, especially in the context of contemporary standards of living, when we discuss what is in the interests of a child versus what is in the interest of a tribe's sovereignty. The United Nations Convention on the Rights of the Child states, every child has the right to a standard of living that is good enough to meet their physical and social needs and support their development. Governments must help families who cannot afford to provide this. Every child has the right to an education. So if a tribe's sovereignty exists in the context of an enabling sovereign power, this means the enabling power needs to step in when egregious occurrences such as food insecurity, housing issues, abuse, or suicide that equally lead to the erasure of a population occur, which the creation of reservations has facilitated. Why is the discussion not about preserving culture and assuring that Native children placed outside of the tribe must be reasonably exposed and allowed to be involved in their tribe of origin after adoption? I'll leave it at that because that was before I get into the second part. Any thoughts?
There are, for some placements, there is a move that, to what extent can the adoptive family provide and facilitate connections to the tribe, especially if they're non-native, similar for the foster care family. But I think there is a general recognition that like a cultural class or attending an event is not a one-to-one substitute for growing within the context of a culture and community. And I think there is similarly, like ICWA recognizes that like a certificate is not a substitute for family connection. And so generally, I think ICWA stands for the premise that being able to have meaningful family connections is the priority. That being said, I think, part of this is a note that I think the recognition that poverty is real and that like food insecurity is real, and that like we're like ICWA, the misnomer I think is that ICWA is willing to tolerate higher levels of neglected abuse than they would if there was an ICWA is false. I think that children do have right to food and to safety and to shelter. But I also think there's a recognition that children also have a right to family and connection and context and history. And so how can we balance all of those, particularly in recognition that there were explicit efforts to sever that culture, community, and history. But so I think the point is really valid, that like poverty and substance abuse are very extremely real and can often outweigh other concerns for a child. And so by no means I think is ICWA ignoring or dismissing that. In fact, I would argue that active efforts is attempting to more explicitly interact with those issues than simply just terminating parental rights and moving on to the next one.
I would add that one of the things about child welfare as a general matter is that these are the kinds of cases that typically are closed. These proceedings are done behind closed doors. Michigan is an outlier, and in this state, child welfare proceedings are still public, but most places they are not. And as a consequence is that we don't have much data on what actually happens. So, for example, if a state court confirms an adoption of a non-Indian foster family of an Indian child and says, and by the way, they have to have a meaningful cultural connection, I guarantee you that's not going to be enforced. Maybe the foster family will do it, but probably they won't. They'll probably change the kid's name from something that sounds indigenous to something like Larry or Steve, and then they probably will never see the reservation again. And pretty much all the big high-profile cases that we know about, where we know who the kids are and their privacy rights, by the way, are horribly violated, we know that they have little or no connection. The non-Indian foster families rarely do anything meaningfully to connect them to their culture. And that's anecdotal. We don't really know the data, but that's my overall sense. As to tribal sovereignty vis-a-vis children's rights, I mean, you cannot and should not ethically make broad generalizations like that. Every case is case by case. And my experience is which frankly is pretty limited as a tribal judge. I get almost no Indian child welfare cases in tribal court. These are all handled by the tribal family court or in state court. But my experience is this, that tribal sovereignty does not trump the best interests of the child in tribal court or anywhere else. A child is not placed simply because it's to the best interests of the tribe's continued sovereignty. Tribes have best interests of the child laws of their own, and number one on that is child welfare. Every single time, tribal sovereignty does not trump the best interests of the child. It just doesn't. But tribes are present. Tribes are involved. Tribes do the things they need to do as a party to the case to make sure that the child has the correct services and that the Indian family has correct services, and that any kinds of biases and structural problems that occur in state child welfare systems are lessened by the presence of the tribe in the case. That's what tribal sovereignty is there to do, and it's actually pretty effective. State courts are well known that they will comply with ICWA if somebody is in the room saying you should apply with ICWA. That's usually all it takes. And if there's nobody in the room saying those words, then the state court probably will not comply with ICWA. That's the reality. And tribal sovereignty ensures that ICWA is taken seriously.
Yeah, thank you both. I appreciate that. I think just like you said, there's so many, like an endless amount of factual situations that we could find ourselves in that lead to ICWA being triggered. So I think it's important to avoid generalizations and also to recognize that the presence of cultural connection in a child's life can lead to lots of positive health and wellness outcomes as well. And that's one of the benefits if you think about, again, some of the longer term effects of removal in the boarding school era and some of the epigenetic consequences that our communities are still dealing with. I think that presence of community with the recognition of like some of the very real challenges that reservation communities face is also a part of just wellness of the child that ICWA is seeking to recognize. So with that, I think let's go ahead and open it up to questions from the audience. I'll leave it to Charlotte, I think, to go ahead and pass the mic around.
Hello. Okay, yeah, you can hear me. Okay, does anyone have any questions that they would like to ask Professor Fletcher, Professor Van Schilfgaard, and Professor Montoya? Also, thank you guys. Thank you all for being here. For Professor Fletcher, I was wondering if you could tell us more about your experience as a judge and what kind of cases you handle most often.
Yeah, I have to back into a case that had been going on for about a decade. There were two children that were born to a teenage tribal citizen up in my tribe, and when she was a kid, she wasn't enrolled with a tribe. She didn't really know had a connection to her tribe. She didn't know she was eligible for membership. So informally, she turned her children over, her infant children over to a non-Indian family at church. And this is under ICWA is not supposed to happen, but I mean that's kind of a situation that's fairly typical in the history of child welfare matters with Indian country. And after about a decade, she got her life together. She grew up and she got a job and she was going to school, and she enrolled with the tribe and thought, now is the time for me to go back and try to get my kids back. And the foster family fought her. So she brought a claim, and the tribe intervened, bringing an ICWA claim to try to transfer the case to tribal court. State court judge refused, just flatly said no. The foster parent's attorney opposed the application of ICWA and fought the tribe at every step. The guardian ad litem, which is the attorney appointed by the state court to represent the children, also opposed ICWA, largely just on kind of generalization that ICWA is somehow bad for children. And so the state court judge denied the transfer, actually denied intervention of the tribe, which is flatly a violation of the Indian Child Welfare Act. The Court of Appeals took the case, and it took 18 months for them to issue a mandate saying, no, you got to transfer the case and allow the tribe to intervene, et cetera, et cetera. The state court judge refused to comply with that as well. So now we're about 3 years in. By state court judge, transferred the case to tribal court. It took probably 4 years, 5 years for that to happen. And some of these kids are almost about to age out. They're getting old enough so that they are going to be adults. And so my experience in that situation was the case was transferred to tribal court. My initial Outback Family Services, which is the Tribal Child Welfare Agency, kept the kids in non-Indian foster care. But when you're a foster parent and you receive money from the government to be foster parents, you work for the government. And these parents had to be reminded over and over again that they work for the tribe now, and their efforts to undermine the reunification of the family, their efforts to undermine the mother's continuing efforts to get child custody and visitation rights were incredibly unhelpful and in violation of the law. And I just, again, the guardian ad litem appointed by the state court, the tribe continued that appointment, the tribal court continued that appointment, continued to oppose the application of not ICWA anymore, but tribal child welfare law, and to fight the mother. And it was an incredibly brutal and tragic case. And this was sort of unusual in how long it had gone back and forth between state trial level and appellate courts, but it's fairly typical. I mean, there are structural reasons that are problematic in state child welfare that put foster parents in a position where they believe they have a mandate and an entitlement to continue fostering and maybe adoption of those kids. And the law does not do a good enough job of making it clear that that is not their role. And even if they're doing amazing, great work, and they put themselves in a position where the children want to be adopted by them, and they do it, they're awesome, and there just isn't, if there's nobody else to adopt them, then that's perfectly fine. That's a large majority of cases that come out well. But when they fight, that's the problem. They fight the tribe because of fears that the tribe is just going to treat everybody poorly, and those fears are frankly rooted in racism. They really are. And so that's an ongoing consequence. I would add, in that case, the foster parents and their attorney had, for a brief period of time, followed a plan of action that was a serious problem following the adoptive couple case in 2013. What worked in adoptive couple for the non-Indian foster family that eventually adopted that kid was to go to the press, to go on Dr. Phil, to be this nice white family that was just wanted to adopt a child, and to demonize Indian tribes, to demonize Indian people, to demonize the Indian Child Welfare Act. Incredibly successful, all at the expense, of course, of the privacy rights of all the people involved. And so once that worked in adoptive couple, it started happening all over the country. People started videotaping their Indian children who were in foster care with an eye towards, if they ever have to give up the children in foster care to an Indian custodian, they were going to put it on YouTube, and they did. And it was super creepy and disturbing. And that's what this family in Michigan tried to do. They went to the local paper, and there was a huge front page profile of what a nice white family wants to help these Indian kids, and the tribe is fighting them. And that was all in violation of the children's privacy rights. They tossed the kids out, their names out there, and they attacked in a heavily racially charged way the mother and the tribe itself, all for the purpose of swaying the state court judge. And it worked for the state court judge until they kept getting repeatedly dinged by the state court of appeals.
Thank you, Professor Fletcher, for sharing your perspective on that question. Does anyone else? I think we have time for one more question. Anyone have a question? Hello. I just wanted to ask, given that you were talking about how powerful ICWA is as a human rights act, and yet it's very not talking about human rights and very procedural and focusing more on procedure, if that's a model for future human rights legislation generally, and just specifically within the area of Indian law, given that we have a court that is sort of edging towards, well, let's create an equal society by ignoring inequality? So that's my question.
That's a good question. I mean, so it's like a model, like perhaps internationally, for child welfare. It's hard to say. I think ICWA, even certainly at the time that it was enacted in 1978, but also now, is in the context of what our current child welfare policy is. I'm not super familiar with child welfare, how child welfare is procedurally structured around the world. I'm going to guess, though, that it's relatively similar. So in some ways, I think that it is underwhelming in that it is procedural. It doesn't recognize any positive rights that Indian children have, that Indian families have, that tribes have. And it would, I think, aspirationally, I would like to see that, some more positive recognitions. On the flip side, to the extent that we are combating a purportedly colorblind sense that prioritizes a right that recognizes poverty as neglect and fails to see the interest of family unity, I think ICWA is a potential model for helping to ameliorate that. And I think to the extent we get the closest thing to a positive obligation, I think active efforts is something to say that actually governments are not entitled to be neutral and to be passive, that there is obligations that before we terminate parental rights, we actually have to go out of our way to keep this family together. I think that is really inspiring. And oh, I forgot the second part of your question. That was so good. So I'll leave it there.
That's great. I would add that one thing that ICWA does not get credit for, and it should, is when it was passed in 1978, it was the first nationally acknowledged child welfare code. It was like a model code, and a lot of states had few, if any, child welfare codes that were anything uniform. And we talk a lot about how the states were running roughshod over the procedural rights of Indian families. So you could lose your kid based on a probable cause affidavit from a social worker or a police officer. There was supposed to be an emergency hearing right after that under state law. And the vast majority of states did not require, and sometimes did not allow, those parents who had lost their kids to participate in that hearing. They wouldn't be given notice of the hearing. They would not be given an attorney. They would not be able to present witnesses or testify in the hearing or see any evidence arrayed against them at that hearing. So if they somehow showed up with a lawyer, they would have to sit in the back of the room and watch as the judge and the police officer and the social worker talk shit about them for hours and hours until it's over. And then you lose your kid for months and months and months at a time. And your chance for getting them back was then and is today very difficult. But because ICWA sort of created a minimum baseline rules of procedure, states started to follow that. And over decades now, states are starting to move in the direction of requiring active efforts. They've heightened their burdens of proof for termination of parental rights. They're starting to recognize the need for counsel for families, not just Indian families. And ICWA did all of that work in a way that it doesn't get credit for. It is a massively successful human rights statute. Probably should be updated, but let's leave it alone for a while until the dust clears.
I think it's just such a huge point that child welfare didn't really exist, and so even being able to recognize the liberty interests at stake to have your family removed is arguably as great, if not greater, than facing imprisonment, and it just doesn't register as a due process violation.
Thank you all again. I'm not sure if you can see me. Oh, you can. Okay. Hello. Thank you all again. This has been a really long panel, so I think that we can go ahead and end it here. I just want to thank our three panelists so much for sharing contributing to today's discussion. I think our community has varying levels of understanding of federal Indian law, as well as how the ICWA statute actually functions in practice. And so I'm sure that today's discussion has helped deepen our collective understanding. So to our audience, our panelists have incredible legal scholarship that you can look into if you're eager to learn more. Thank you so much, and we'll see you next week for the next iteration of our symposium. So thank you guys.